Defenses in battery cases can get complicated because there is no one-size-fits-all defense to battery. Oftentimes when people in Florida will bring up stand your ground. The stand your ground laws in Florida have been litigated for years as to which side has the burden to prove and the exact language of the stand your ground law. If you follow cases that have been in the media and the press as it applies to stand your ground, oftentimes you will find that those cases really are dealing with self-defense rather than stand your ground. When it comes to self-defense, again, a person does have the ability to defend themselves if they're reasonably threatened, but there are many factors that go into that. It is important to go through each of these factors with an attorney who understands the elements of both stand your ground and self-defense to see if that applies to your case. Another common question I get when it comes to defenses is, well, there's no evidence. It's the person saying I did it. Well, that's evidence. A person saying something happened is evidence. It may not be the best evidence for the state to proceed on. It might give the state pause and if they want to proceed on a case. It might be good mitigating circumstances to find a lesser resolution if it's just based on someone's word. But do understand that a person's representation, their memory, their assertion, their word that something occurred is in fact evidence. That can be balanced against a person's word that it didn't happen, and then you get the proverbial he said, she said situation. But I can say from experience there are many assaults, many batteries, many aggravated batteries where the majority, if not the entirety of the evidence, is simply someone's representation or word. Again, if you have questions about a battery, aggravated battery, or felony battery case, do talk to an attorney to avail yourself of all of the information, make a firm understanding of the case against you, and avail yourself of all potential defenses.